Today we'll be discussing another component of intellectual property rights, that's a copyright. So copyright, before starting and before jumping into the sessions, let's discuss the learning outcomes. At the end of the sessions, what you can expect out of the session. That is, what is copyright, history of copyright, criteria to get copyright, nature of copyright and authorships, terms of copyright, various provisions of copyright, fair use and prenup testing, infringements and copyright remedies. So let's get started. What is a copyright? Copyright, once again, it's a kind of intellectual property rights that is given to the creator for a limited period of time. Right now in India is a 60 years period of time. And after that it goes to public domain. Public domain means anybody can access it and there is no copyright attached to the content. Presently, in the digital landscape, we deal with normally four kind of things. Obviously, analog things, in addition to the analog things, we deal with the audio video things and the digital text and the images. So all these four kinds of things, that means the textual things, audio video and the image. Image are two types, vector images and the raster images. Based on that, the different copyright duration varies. The idea, the history of the copyright is a very fascinating history because history is once again it's almost 600 years back. Johann Gutenberg, when first invented this printing press, the cultures and the practice of the knowledge started, and it was introduced in England by William Caxton in 15th century. So in the 15th century, another thing happens. People started acting on this learning voraciously, printing voraciously. But there was a problem cropping up in those days. What happened? There was no such regulations or the governing act by which all these activities can be controlled, governed, and regulated. So, world's first Copyright Act, the Statute of Anne 1710, was passed by the British Parliament. So, like patent or like any other intellectual property rights, what are the basic criteria? The basic difference between the patent and the copyright is, to get a patent, you have to apply to the Indian Patent Office or any patent office of your preference or a choice. You have to apply. Moot point is you have to apply. Without applications, you cannot get any patent protections for your inventions or innovations. But it is just opposite of copyright. Copyright, whatever you wrote, whatever scripted something in an analog form or a digital form, it's entitled for copyright, provided there is a caveat, provided that you give the proper acknowledgement based on which that material, that's a copyrighted content that you are claiming your own ownership, you have given the proper credit to that material that you have used for your derivations. So that means three criteria you require. Normally, copyright is a spontaneous or automatic right. As I told you, you have to give the proper acknowledgement or the credit to the persons or the material that you have used for preparing your material. But copyright registrations, you can do it if you anticipate for whatsoever the reasons. If you feel that in future, after 2 months, 3 months, 2 years, 20 years, if you feel that your copyrighted content may be stolen by somebody else or some organizations, so you can go for its registration. So it is always advisable to go for a copyright registration. So what are the basic criteria to get a copyright? Copyright needs to be fixed. That means copyright needs to be fixed means it needs to be written in an analog form or a digital form. It needs to be expressed in some form, analog form or a digital form. And it must have some originality factor. In the novelty factor is applicable for patent, but originality factor applicable for copyright. What is the basic difference? Basic difference means if you apply for a patent office, patent examiner will verify it voraciously. Very strong examinations. Novelty means nowhere it is available. Original means original writing, original copyrighted content, you have used some derivative work, somebody's work, but the concept that you have created out of that, it's original. So examinations of originality is much lesser grade. Instead of this patent, there is a huge and a strong examinations grade. And most important, the copyright examiner, they try to find out what are the creativity factors that are involved in the copyrighted content that you are claiming of your ownerships. So there are three criteria. It needs to be fixed, it must be original, and the minimal creativity factor. Different works covered under this copyright: literary, dramatic works, musical works, artistic works, and it is given for 60 years period of time. Anonymous works, pseudonymous works, 60 years period of time. Works of public undertaking, say for a government office, they are always producing some technical reports, white papers, memorandum, notice, notifications, and everything. Obviously, everything is a copyright. So that is also given for 60 years period of time. Works of international organizations, many say for United Nations, FAO, Food and Agriculture Organization, International Atomic Energy Agency. So there are United Nations Environment Program. So different international organizations are there. They are producing the lots of documents, digital documents, analog documents. They are also having opportunity of 60 years period of time. They can enjoy only 60 years period of protection for their copyrighted content. Sound recordings, 60 years period of time. Cinematographic films, 6 year period of time. And let me tell you, in this context, it's very surprising. In a film or a movie, producer gets the authorship. That means producer gets this copyright for the productions. I will let you know the logic behind it. Logic behind it is because without producers, a film, the apex of all kind of artwork cannot be produced. That means lyricist is there, musicians is there, performers, actor. So different people are connected with this artwork. But this artwork would not have been see the daylight without the sponsorship of this production that the producer. So this is why authorship is given to the producers. Obviously, the persons who are involved in the creative work, say for a lyricist, say for a musicians, music arranger, choreographer, every person has an individual copyright for their own works. But overall film copyright is given to the producer only. Okay. So another dichotomy in the copyright discourse is idea and expression dichotomy. What is that? Idea. In the discussions of the intellectual property rights, I told you, you can refer back to my first lecture and you will find that I told it idea is not protectable. Only the expressions is protectable. Let me give you a real life example. Say for Indian national movement. It is, say for the durations in Indian national movement duration is 1905, roughly 1905 to 1947. That means Indian national movement. Suppose three authors A, B, C have been given this assignment to write a book on this Indian national movement during this period. Okay, and three authors have written three books on the Indian national movement. Maybe the title of the book is different, but the subject is same: Indian national movement. Do you think all three persons are entitled to three copyright, or the three copyrights, or the only one copyright is given to this all three persons, or the one copyright that will be shared by three persons? Okay, so as per the Indian Copyright Act 1957, as the expression of the three authors would be supposed to be different, maybe the idea is same, so three copyrights would be given to the three authors. So that is the idea. So idea is Indian national movement, but expression of A, B, C author would be different. It is supposed to be different. So this is why expression 1, expression 2, expression 3 that has been expressed by A, B, C, three authors, just for an example, would be given three copyrights. So that is the dichotomy of idea and expression. So nature of the copyright, you can notice that copyright, once again, it's a negative right. That means very similar to the other form of intellectual property like patent or any other IP forms. Negative right means rights of alienation is equally applicable for the copyright also. That means rights of alienation, if you say this is my musical video, or if you say that I have written these lyrics of this particular music or particular song, that means don't use my lyrics at least for the commercial purpose without my permission, not even for the non-commercial purpose. Intangible property, I told you, intangible property, it comes from a human mind. So copyright idea is also comes from human mind. It's a time bound. It is given for 60 years period of time right now. Earlier it was a 50 years period of time. But due to this Gurudev Rabindranath Tagore's copyright was given to Vishwa Bharati and it was limited to 50 years, that period of time. When it was expired, Government of India to respect and honor Gurudev, 10 years escalated period was given to copyright escalated period given to Vishwa Bharati, and since then the total durations of copyright in India has been escalated from 50 years to 60 years. It's a quite historic and landmark change in Indian Copyright Act 1957. It's a territorial, that means your copyright is given by Indian Copyright Office. That means your copyright or your ownership is only available within India. If your book or if your material is published in US, that means your copyright jurisdiction should be limited only within US. But here, one thing I need to mention, suppose in Amazon, let us pick up one example that Amazon are selling different books published in different zones, different countries in the world. Do you think a book published in India maybe selling in Germany or vice versa, don't they enjoy any copyright over here, or any person try to violate their copyright in India? Originally the book has been granted copyright in Germany and that copyright is violated in India. Do you think it's not protectable? Yes, it's a protectable, because almost all countries are member of these international agreements, different international agreement, international copyright agreement. That's a 1999 order, and based on that, all countries will respect and protect other countries' copyrighted content in their countries as per their domestic content. So that is the thing. Otherwise, most of the countries' copyrighted content is protectable only within that territory. And when we talk about this copyright, we always talk that the copyright, we understand the copyright is a single right. Most of the people do understand the copyright is a single right. No, copyright is a bundle of rights. And no copyright is given on any idea. And what are the bundle of rights? I will let you know. So, copyright, when we talk about this copyright, more or less we talk about this economic right. That is, you can sell and you can get some economic benefit out of that. But one copyright is also there that is not assignable, that is not transferable, that is never cease to happen with the creator, because copyright is a kind of entity or a concept where creator is creating something, and where this creation, your book, your any kind of artwork is basically your brainchild. When we are talking, when we are terming something is a brainchild, that means the creator is the mother and the creation is her child. So his or her creations is connected with mother, that means creator, umbilically, and that the way a mother is connected with a child, it's never cease to happen. Umbilical cord, that never cease to happen. So this is why moral right is never transferred. Suppose how it can be implemented. Suppose you are the painter, you have sold a painting for the economic benefit. Somebody has taken away your painting, but after that, suppose picture, he wants to deface it. He wants to make a caricature. Obviously, caricature has a different copyright. That's a different thing. Just because of the lack of the time, I would not be able to discuss all these caricature aspects over here. But we cannot deface it. We cannot deface somebody's painting as because I am the owner of that painting. If you do that, if the painter, original painter who has sold this painting, if he or she wants, he can drag you to the court, and court will give verdict his or her favor. You cannot do that. So copyright consisting of two types of rights. One is the economic right, another one is a moral right that never ceases to happen. It always lies with the creator. Copyright is a bundle of rights, as I told you. Copyright means the rights for reproductions, rights for derivative works, rights for adaptations, rights for translations, rights for communications to public, rights for distribution, rights for public performance, public display. So all taken together, it becomes a copyright. Copyright is never a single right. Who is the author? In case of a literary work, we understand for a textual book, we understand who has written this book is the author. In case of a musical work, the composer. Cinematographic film, as I told you, the producer. In case of a sound recording, the producer. In case of a photographer. In case of a computer generated work, because computer programs right now under the category of artistic and literary work, so it is controlled, governed and regulated by the Indian Copyright Act 1957. It's a copyrighted content. So terms of copyright, as I told you, 60 years. But how this 60 years will be counted? Suppose a book is written by four authors and 60 years period of time, say the last author dies in, say, for a November 23, 2024, but this 60 years would be started counting from 1st January 2025 up to 60 years. This way the counting starts. Anonymous, pseudonymous, posthumous work, cinematography, computer programs, sound recordings, international, all are 60 years. And the period is counted from the date of first publications. Here the counting is something different. Period starts from the beginning of the next year following the year in which film was first produced. See this. Performance rights and broadcasters' right. It's only 25 years instead of 60 years period of time. In film actor and actress do not have any copyright. They have only the performance rights. Broadcasters who are broadcasting, say for any sports or any tournament, when it is that broadcasting rights are purchased by some big name, say for a Sony or a big names. So G, this way they purchase these rights, and these purchase rights once again they sell it to other distributors. You know it very well. So these performers rights and broadcasters rights enjoy only 25 years period of time, and it is not a copyright. It's called copyright and neighboring rights. Comes under the neighboring rights. These performer rights and broadcasting rights comes under the aegis of these neighboring rights. Few important terms if you want to understand deeply copyright, you must understand 2-3 terms very deeply. So one is a transformativeness. Suppose you are using for your scholarly works or your academic job, you are transforming some work. Say for you have read one poem. Based on your idea, imaginations and interpretation, you have transformed that poem into a cartoon work. Do you consider that you can also be entitled to get a copyright of your cartoon work? Yes, you can. Adaptations and the derivative work, suppose based on some Satyajit Ray's story work or storybook. Can you go for any cartoon? Yes, you can go for a cartoon, and that is also adaptations and a derivative works. You can also entitled to get a copyright. Transfer of copyright, that means selling your right. Well, you are selling your property, very similar to that. Transfer your copyright. That means when you are transferring your copyright, when you try to publish any article or a book chapters or a book material with the publisher, you transfer a copyright to the publisher. And there are two important terms are there. One is the assigning licensing, and another one is the exclusiveness and non-exclusiveness. Assign means simply is a technical term, but in a colloquially it means you are selling your works. License term means is a kind of permissions. Without permissions, you cannot use anybody's copyrighted content. License means is a permissions. Exclusiveness, suppose you want to publish your book with some publisher XYZ, but if you do not sign the exclusiveness or non-exclusiveness, it most of the cases is likely to be considered as exclusive. You must mention non-exclusive. If you are not happy with the kind of royalty or any kind of services being provided by the publisher, certainly you might not be happy with that exclusivity. So you can go to the another printers or publishers for that. But if there is transfer of agreement is based on exclusiveness, you cannot go. So always provide non-exclusive license to your publisher, so that if you're not happy with the publisher for whatsoever the reason, you can go to any publisher of your choice. So I told you international copyright protection, there is no such thing, international copyright. But what really works? India is a international copyright order 1999. India is a signatory in several international copyright treaties. The International Copyright Order of 1999 was enacted to provide protections to foreign works and their authors and the creators. Both civil and criminal remedies are eligible to foreign works also. Even in the patent chapter, I discuss work for hire provisions. Work for hire provision, suppose you are working in a university or a college or any higher academic institutions or any academic institutions or any institutions whatsoever where your creative works. If a person in the course of his employment under a contract of service or apprenticeships creates any work, his or her employer becomes the first owner of the copyright. So if you are producing any kind of copyrighted content under the definitions of the Indian Copyright Act 1957, so your authority, that means a employer, would be the first owner of your copyrighted work, and there is no contract in the contrary to section 17C. So if you violate that, certainly it's a punishable offense. And one most important thing, almost all intellectual property rights forms, say for a patent, design, trademark, copyright, and other forms are also there. All any violations are normally dealt by the civil laws. Only in case of a copyright, this is dealt by Indian Penal Code. Right now, it's currently renamed as a Nyaya Sanhita. Let me discuss one very serious issues related to the copyright. There's a subsidiary rights. Let me share one very interesting story. One of my friends published a book in Bengali, and he's a very good author. He might be from physics background. Right now, he's working in Germany, Munich. One fine morning, he called me back and asked me that my book is available on Amazon. But his surprising factor was that he was taken aback that he found that he wrote that book in Bengali, but that book is available in Amazon in German language. As he knows me that I have been working for more than 2 decades with this intellectual property rights, so representing United Nations as an Indian member. So he asked me, what is your opinion? How can it be? What are the remedies available to him? Because he has not written any book in a German language. He didn't know. Maybe he is staying in Germany, but he's an international researcher. He knows only English and little bit small German, very working Germans. So immediately he wrote to publisher. Publisher has told, yes, you have already given to us a subsidiary rights. Now the question comes, what is subsidiary rights? Now he started threatening to publisher, I will drag you to the court. Then I told him, please share your publishing agreement, transfer agreement, what you transferred. Then I found that most of the publishers are honest, sincere, genuine, but some unscrupulous publishers are also there in the market. While you are transferring your copyright, they provide it very similar to our LIC kind of, when you are subscribing to any schemes of LIC, you will find that very small fonts are there. When, God forbid, any wrong thing happens over there, you will find that smallest fonts becomes so magnified. The moot point is you are not going to get back your money. So that's the thing. Copyright and subsidiary rights. Try to recall. I told you copyright is a bundle of rights. Copyright means also includes translation rights. So when he has transferred, I found his agreement paper. He has already given that rights because he didn't have any idea on this copyright. So what he did, he immediately signed over that with super excited that his book is going to be published. So-called reputed organizations, reputed publishing house, but publishing house given this one sentence, I am transferring my copyright and subsidiary right. That means you have already transferred all kind of rights possible under the Indian Copyright Act, including these translation rights to the publishing house. Then I tried to make my friend understand this is the implications and this is the consequence of your ignorance. So that is the subsidiary. So whenever you are trying to transfer your agreement, a copyright to any publishers or whatsoever the entity, always try to provide for how many years you are giving this license, and you must not give it exclusive license. Always give non-exclusive license. And what kind of rights you are transferring? You ask them what kind of rights you are asking from me. Okay. So registrations or copyright is possible. You can go for it. Copyright.gov.in. As I told you at the beginning of my lecture, if you face or if you feel that or apprehend some kind of wrong thing might happen in the times to come, so you can go for its registrations. Is always advisable, and it's a very cheap. Unlike this patenting system, patent application is a very expensive, but copyright registration fees is very cheap. For literary dramatic works, only 500 rupees. Cinematography 5,000 per work. Sound recording 2,000. And you can directly go for online applications, copyright.gov.in. And if you want to republish, re-editing your book, reprint, 5,000 per work. Cinematographic film for reprint, 15,000. Sound recording, 10,000 per work. Safety valve of the copyright in the section 52, it is very important for our students or teaching or academic community, when you are writing something, you always in the fear whether I am in the right side or the wrong side of the law. Because as I told you, Copyright Act of Indian Penal Code, right now, Nya Sanhita, so it's a criminal procedure. Violation is a criminal procedure. So how do you find out yourself, your activities or using of any copyrighted content comes in the falling in the right side of the law? And there is a four-factor analysis. We call it's called PNAM testing. Purpose, nature, amount, and marketing. What is your purpose? Is it for non-commercial or commercial? You ask yourself, and it should be very genuine and sincere when you're answering to your questions. And the nature, it's an unpublished work or a published work. Amount, how much portions of the copyrighted content you are using for your derivations or transformations, whatever. So marketing, after selling your product, if you think you want to develop some copyrighted content which is a sellable, is it impacting the original content? Very similar when every day, every year, there is a Sharodiya, and there is a kind of Puja Shankha published. The next day, we expect the same thing is available, should be available in our WhatsApp. If you publish the same Puja Shankar or Sharadiya with your own creations, do you expect the same thing the way you expect for others' works? Everyone's others' works has a free right, but do you consider should be available to everyone free of cost? In that case, publishers would not be interested to publish your work because there is a mutualistic relationship that exists between a publisher and the author. If they do not get any economic benefit, certainly they will not be interested anymore for publishing your work. So that's a very important aspect. So PNAM factor, purpose, nature, amount, and marketing. But in our Indian Copyright Act 1957, we call it a fair dealing. In a US Copyright Act, this is fair use. The term fair use is much popular in the world. Copyright, qualitative and quantitative. Suppose I'm giving a practical example so that you can understand it better. Suppose a book is there. Obviously, it's a reference book, research reference book. Suppose there is a 5 chapters, and the say for a third chapter is a core chapter. As per the UGC Act, 10% you can go for it is allowing for the similarity check or the allowing for the copying. But that is absolutely full of fallacies. Why am I telling that? Maybe the book consisting of 300 pages and the central chapter, as per the author's claim, the third chapter consisting of 19 pages. That means it's a less than of a 10%. If you copy that central chapter, you are copying the qualitative content. That means it's unfair. And obviously, you should be penalized for that. Copyright infringement, and there are one sections. Copyright infringement section 21, when any persons without license granted, suppose you have not given any license, any permissions to anybody for using your work, but still somebody is using and selling it, certainly it's a direct copyright violations. But when you are try to follow these pictures, you will find that there is a striking similarity. Striking similarity when we try to find out similarity between two works, maybe the analog or digital work. We try to find out the errors. We try to find out the idiosyncrasies. So idiosyncrasies tells you the story, original story that you have copied somebody else. Because as you do not have the original idea, so you do not know what there is an error lying. So this is why idiosyncrasies and the finding out the errors is the striking thing, most important thing when you are trying to find out similarity between two things. When there is any copyright violation, you can ask for both kind of remedies. One is civil remedies and the criminal remedies. In civil remedies, you can ask for injunction, that means, and then damages, accounts, and the costs. And the criminal remedies, cognizable offences, imprisonment up to 3 years, fine up to 2 lakhs. So today's discussions, basics, copyrights, and the related issues. So thank you.